Massive thank you as always to our top tier patrons, Sarah Turner. It's Not Just In Your Head is hosted by psychotherapist Dr. Harriet Fradd, substance use disorder counsellor Eco Hero, and myself, the editor and producer Liam Tate. This podcast is entirely funded by listeners, and as the famous meme states, we are critiquing capitalism because we are forced to participate in it in order to survive. So, if you can afford to give, then your contribution will ensure that we can keep making this show. However, if you can't, then please leave a review on your podcast platform of choice, tell your friends about us, and follow us on Twitter, Facebook, Instagram, TikTok, Reddit, or YouTube. Also, a massive thank you to Elle for organising our monthly reading groups and episode discussions, which you, dear listener, can join too. Just head over to our Eventbrite page. The link is in the show notes.
In the mental health field, too often, we've made it seem as if it's just in your head.
The landlord can hijack the rent by 20%. That impacts people's mental health.
Can't have a profit-driven mental health care system if we want our people to be connected and healthy.
So would you like to, for our listeners, would you like to do the intro about yourself and what you do?
I am a Social Security disability claimants representative. That's what Social Security calls the generic job title. Attorneys fall under this, and there's lots of non-attorneys that fall under this. I'm one of the non-lawyers. My specific credential is a mouthful. The abbreviation is EDPNA, which stands for Eligible for Direct Payment Non-Attorney, and representative or advocate goes after that. Sadly, even though Social Security made it up, most of the Social Security employees don't know about that credential that they created.
Oh, wow.
Yeah, the judge, I'll go into a hearing and the judge will be like, are you an attorney or non-attorney? Well, there's two flavors of non-attorneys. There's EDPNAs like me, and there's anyone from somebody's uncle to a lot of legal aid societies just use paralegals. In fact, I applied about 5 years ago, I think, or something like that, to work for Inland County Legal Services, which is the Inland Empire, California Legal Aid Society in like Riverside and San Bernardino. And they
wouldn't let you?
No, they were happy to have me. They were actually thought I was over credentialed. They're like, why are you applying here? We don't need your credential because we don't get direct payment. We get grants. Because legal aid, they don't charge a fee to the claimant.
Right.
Everywhere I've worked for does. And the EDPNA, the only advantage to getting the credential is that you get paid the same way the attorneys do, which is Social Security withholds the fee from the claimant's past due benefits so that you don't have to go billing them. And if and as long as they don't go file for bankruptcy, you can get your fee. That's the advantage to the attorneys, and that's the advantage is to getting the credential is you get a guaranteed fee from a population that really otherwise would be in trouble if they tried.
Yeah. Thank you for explaining your credential. The reason we have you on here today is to kind of disabuse some of the concepts that surrounds disability payouts, because a lot of the social colloquial understanding of disability oftentimes is that one, it's easy to get, and it's two, full of malingerers that you don't want to work.
Oh, right. Gosh. I have a quote for you on that specific topic.
Please go ahead.
This is why we fight kind of thing. And I'll give you the citations for both of this because this was originally written by one guy and then some administrative law judges picked this quote up and applied it to veterans, which made it even more offensive because the quote's pretty offensive in and of itself. Here's the quote. In providing old age survivors and disability benefits, it usurps the individual's responsibility to make prudent provision for his old age or disability and for the well-being of dependent family members who would suffer financially if he died. This was written by John, I'm going to butcher the name, Atarian, in Is Social Security Reform Paternalistic? This was, that's the name of the article. It was published in the Freeman Ideas on Liberty, name of the journal, the January-February edition in 2004, and it's found on page 10 of that journal. And that quote was then republished in a different article by a hearing office chief administrative law judge and another administrative law judge from the Social Security Administration, commenting on veterans' disability compensation. So this is the VA program for vets who got injured while serving the United States in some capacity, or who got injured while being medically operated on or treated in the VA. And the names of the two judges are David E. Engel and Jeffrey S. Wolf. The article that they republished that quote in was Paternalism and the Rise of the Disability State. It's in volume 37 of the Journal of National Association of Administrative Law Judiciary. The article starts on page 355, and the quote can be found on page 470, and that was published in 2017. So this is fairly current.
Right. Yeah, this is a very pervasive colloquial understanding in society that greatly needs to be disabused. And you are the perfect person to kind of walk us through oftentimes the major hurdles and issues that people face between becoming disabled and getting disability payments, and then also the restrictions imposed on people who receive them.
Let's start with that quote. Why that quote's wrong. Think about the average ditch digger. We still have those, by the way.
Yes.
Those haven't gone away.
Yes.
It's one of the few jobs we did not ship somewhere else. And for the vocational witnesses / experts in the audience who might be listening, we're talking about Dictionary of Occupation Code 869-687-026. That's someone who may get in an injury on a work site when they're 30. You know, maybe they'll get a progressive condition like a degenerative disc disease that will hit them in their 50s or 60s. But what if it hits them in their 20s or 30s? You know, something falls on them or whatever. The on-the-job injuries have not been abolished. Or the two Social Security Administrative Law judges commenting on the VA program and applying that quote to the VA program. What about an 18-year-old soldier who gets hit by a bullet or an RPG round or whatever? Providing them VA compensation benefits or disability insurance benefits, or in the weird off chance that neither of those apply, SSI benefits, that's taking away from their personal responsibility. What, they're going to have $1 million socked away at 18? That's absurd. That's absurd on its face. Whether or not the retirement program is a good idea, fine. I can understand some libertarians trying to debate that, but the disability? No. That's absurd on its face.
It is. It is absolutely. Well, can you kind of explain for our listeners the different disabilities that you just mentioned?
When someone gets injured or has a sickness, there are many different legal filings that can happen. Sometimes it's personal injury. Sometimes it's workers' compensation, both of which feed into illness, the Social Security program.
Or chronic illness.
Chronic illness feeds in separately.
Okay. I did not know that.
Yeah, because, some people, when they have a personal injury, a slip and fall or any number of other personal injury lawsuit type things, some of those are permanent or relatively permanent. Right. And if it lasts over a year, Social Security can jump in at that point. If it's, one surgery and you're done, Social Security is probably not going to get involved in that. Okay. But there are personal injury lawyers who get into Social Security because a sizable number of their clientele also need Social Security benefits. And why their reasoning is, why should I farm that out to some other firm? I can do it in-house. Okay, that's reasonable enough. Same thing with workers' comp. There's a ton of workers' comp lawyers who also do Social Security law because a huge number of their clients also qualify. And then you have people who get short-term or long-term disability benefits. A lot of the long-term disability carriers have a provision that requires the person to file for Social Security disability insurance. And that actually clogs the Social Security disability insurance administrative system, because you have people who don't qualify for Social Security who keep applying because they signed a contract that said they had to. And the insurance companies get a subsidy, kind of, from Social Security, because if Social Security does pay, then those...
that they have less to pay out. Ultimately.
Yeah, the insurance companies, the long-term disability don't have to pay out what Social Security is paying them.
Right.
And so these clients really don't care if they win or lose. They are the most disengaged that you can possibly get. And then another group that falls in are veterans. Veterans do not, in Social Security, there's a provision where if you're getting a government benefit, which workers' comp counts as, they will pay you less because you're getting a government benefit. But there's an exception. That exception is for vets if they get it through VA. If they get it through the Department of Defense for exactly the same condition and exactly the same rules, then they have this windfall provision that reduces the amount of benefits they get. But if they get their benefits through the VA, that windfall provision does not apply. You don't see many vets who get it through the Department of Defense anyways. It doesn't come up very often, but it does sometimes. And then you just have people who have chronic illnesses or got into car accident or whatever.
Permanent injury.
And something happened and now they're medically unable to work. And depending on if they're poor, and by poor, we mean exceptionally poor, like they have less than $2,000 in the bank poor. That's when they can get Title 16 benefits, which is technically called supplemental security income. I hate using the colloquial term for it because everyone thinks SSI and Social Security are the same thing. And Social Security administers SSI, but it is not part of the Social Security system. Those come from two very different pots of gold. Social Security is what people call Social Security is an insurance program. And the total name for the insurance program, which has two trust funds, is the Old Age Survivors and Disability Insurance Program. And that encompasses the whole kit and caboodle. That's the retirement program. That's the adult disabled children's program, the widows program, the children's benefits for people for workers who have paid into the system but died, became disabled, or retired. And then obviously the workers who became disabled.
Right.
Then you have Title 16, which is a welfare program. That's the SSI. What SSI stands for is Supplemental Security Income. And that kind of tells you how it pays. It guarantees that you won't have less income than a certain amount. But as a consequence, they subtract out resources you get from other places to get you that floor, because they're guaranteeing a floor. And so you can have people who get the Title II program, whether that's disability, retirement benefits, and SSI, because their Title II benefit is too tiny to not qualify for SSI. But most people who get Title II are too rich, which is hilarious in a sick way,
Right. Well,
to get SSI.
So what is the cutoff point for too rich? Do you know?
That's a complicated question, because there's a lot of different cutoffs, because they consider assets, resources, and income as like separate buckets to cut you off. And assets, that's pretty easy to explain. We're talking about like houses, cars, property with dollar values. Generally speaking, they don't really mess with personal property too much. You know, it's not like they send someone over to your house and they go, okay, I'm going to count everything you have and put a dollar tag to it. Even I don't think even the bankruptcy court trustees do that, although they can. But I don't think they bother. But Social Security definitely doesn't have the manpower to do that. So no, unless you have some rare collectible that they know about, they don't care. It's about tiny personal bits. But you get one house for free, you get one car for free that they don't worry about. Everything else. And this is how you have people on SSI who own a home. You might think, oh, wow, they own a home. Why don't they sell their home? And Social Security is not trying to increase the amount of misery and poverty in the universe. They're trying to decrease it. But Congress hasn't updated their rules since, I think, the 70s for the asset limits and so forth. And then on top of all that, something that applies to both programs is the substantial gainful activity limit. This defines you out of being disabled by virtue of working too much. And there's a lot of controversy about this, because a lot of claimants, when they talk to their representative, lawyer or non-attorney, about this, what they hear is, oh, I can only work up to this amount. That's not how this works. It's the dollar amounts are supposed to be a guide to, if you can work and produce this much value per month, then it doesn't matter what your medical condition is, you're not disabled by definition. And these dollar amounts are low. They go up every year. And
but they're still the low.
Oh, yes. I'll give you some of these to give you an idea. And it's important to keep in mind that there's a difference between blind and non-blind. So both Title II and Title 16 are actually divided in twain between blind and everybody else in terms of disabilities. Blind people get special privileges, including they get to make more money. And they do not, as long as they made their insurance requirements are way less stressful. They basically don't have a date last insured if they are insured enough to qualify for the retirement benefit. So if you worked for 10 years and you stab your eyeballs, I'm pretty sure under Rule 4, you can get blindness benefits at any time.
What if you do? So what if you never worked before?
Then you can get SSI, or if you get it early enough, if you're like born disabled and you had a working parent or grandparent you lived with, you can get adult disabled children's benefits, which are better in a lot of ways. The only problem with adult disabled children's benefits is you cannot marry if you get that. and you cannot ever trying to return to work, which Social Security will really encourage you to do, is way more dangerous for adult disabled children's recipients than anyone else. That's the one that is. I advise everyone, if you can, return to work, but that's the one we have a much longer conversation on, because if the Social Security definition of sustainability is, can you sustain work for over 6 months? Well, if it's not clear whether you're at that 6 to 7 month boundary, that can be really devastating for someone on adult disabled children's benefits. Can they really sustain it? Do they know? And will their employer fudge it to allow them to be on the payroll longer than they really should? And then can we prove that later? That can get tricky. Those are very tricky things. And they need someone who's going through that needs to be made aware. Hey, you might lose your benefits for life if you cross the line, and it happens for stupid reasons, not legitimate reasons. Like, an employer was nice, but they don't write a letter to demonstrate that they were being nice or something. So, like in 2023, if you're not blind, it's $1,470. That is the substantial gainful activity amount.
So that's the amount you can work, right?
Well, that's the amount that if you can make that much money from work per month, you are not disabled, with some exceptions.
Cover rent.
Now, here's the blind amount, the blind equivalent, $2,460.
That's still not much.
No, it isn't. And that's in 2023. Now, you go back to 2020, here's the non-blind amount for 2020, $1,260. What's it for blind? $2,110.
Well, this is kind of, I think for a lot of people that aren't necessarily familiar with the entire process, do you want to for, say, somebody that's chronically ill or chronically injured, do you want to walk people through the process of getting the SSDI?
Okay, that has 3 answers. And I'll walk you through all 3. So there's the process answer, which is, what do you do? And the what do you do is you apply for benefits. And as I mentioned earlier, there's 2 programs. If you worked, you probably want to apply for Title II. But I also recommend you apply for Title 16 in case your date last insured is very short. Date last insured can be a maximum of 5 years after you last worked, but for some people, it's a day or something. So, because it depends on how much you worked, that 5-year grace period. The best way to think of it is like car insurance. When you pay into car insurance and you stop paying, they will cover you for a short period of time. And then after that, it doesn't matter how much you paid in or how bad the accident is, they don't cover you. Well, date last insured works the same way, except for instead of being the date that they stop covering you, the date last insured is the last day they do cover you. And it's always the end of a quarter. So it's really easy to find out what the date last insured is. And so Social Security sometimes just writes it as a month and a year because it's always the last day of the quarter. So it's either the 31st of March, 30th of June, 30th of September, or 31st of December when the ball drops. So I recommend applying for both programs in case that date last insured is an issue. And then after that, after your application is turned in, the field office will determine, and the field office is what you think of as your local Social Security office. That's what Social Security calls that local office, because they have other local offices, which we'll get to in a minute. About 30 33%, about a third of the cases are favorably decided at the initial stage. And within this initial stage, it's divided up into two parts. So the field office will determine if your non-medical qualifications are in order. So for Title 16, are you poor enough? For Title 2, are you insured for the period that you claim you are disabled? Then they hand it over to your local state agency. Every state has part of usually it's the part of the department that handles unemployment insurance, interestingly enough, that Social Security pays for everyone in that office that handles the Social Security claims. And they make the initial and reconsideration determinations that I'm going to be talking about in this process answer. So that's the state agency. They have doctors. Usually it's a team of a bureaucrat, one physical doctor, and if there's anything psychiatric or psychological about the disabling conditions, they will have a psychologist or psychiatrist review the medical records. And they will decide if you need to go see a consultative examiner. This is a doctor that they pay for to examine you with the quality of varying degrees. I object to a lot of them. So my opinion is rather dismal. Of course, right. I also object to a lot of the state agency medical consultants. So my opinion of them is also rather dismal.
Right. I mean, their job is to deny claims ultimately.
No.
I mean, not. Obviously, that's not a formal, role, right? But
yeah. Well, it's weird. It's weird.
It ends up feeling.
Well,
like...
they actually at the initial stage they grant the second most amount that anyone gets granted until very recently. The federal court has gotten real active since Social Security did something to try and make federal court less active. But we'll get to that later after we get through these three ways of getting benefits. So they grant about a third, and almost all of that third is medical listing stuff, which is why at the hearing level, you almost never see medical listings.
So what is medical listings?
I'm going to put a pin in that and come back to that because I said there were three different ways of looking at this. That's one of the other ones. So I'm going to put a pin in that and come back.
Right. Okay, fair enough.
And they're terrible about the grid rules. I'm going to put a pin in that and come back to that as well. After the initial determination, you have a chance to appeal. That's called reconsideration. What it basically is if once you get denied, you can appeal it to the same state agency, basically, although you do it through the field office. The field office works as the intermediary. So you actually send the appeal to the field office, and then they send your file back to the state agency to redo it. The only difference is they send it to different doctors and different bureaucrat. You'd think that would make a difference. Fundamentally, it doesn't. The percentage of different determinations at that stage is about 10% year in, year out. All of these percentages I'm giving you vary from year to year. Some years it's a little higher, some years it's a little lower, but initial determinations hover around 33%, 33 and a third percent granting. Reconsideration hovers around 10% granting. So that's a real rubber stamp. And Social Security experimented with getting rid of reconsideration. The reason they didn't, even though it was a major plus for everybody, the reason they didn't is people generally stop pursuing their claim after reconsideration. And that's very silly. And we're about to get to why that's silly. But people do it because they get discouraged. And so Congress kind of leaned on Social Security to keep it in, as I understand it, because Social Security was having to ultimately award less benefits by keeping reconsideration because people were quitting pursuing their claims because they were getting discouraged. So after reconsideration, you can request a hearing. This is the first time Social Security actually rules on your claim as themselves. So they yank it from the state, and this can get a piece of advice for everyone listening. You want to keep all the medical records that may have been requested by the state agency and keep a copy for yourselves, because the state agency only has to send to Social Security's Office of Hearing Operations the stuff that supports their denial. And I think you can probably figure out that this means that they may sometimes omit stuff, even stuff that they requested. Like, so there have been times where there have been consultative examiners that we didn't get to see because it was done at initial and reconsideration. This was a long time ago when I was monitoring this, and we would notice that these consultative examinations, that there was evidence that they had been requested, there were evidence that they had been done, claimants said they went to them, and they didn't appear in the exhibit file because it didn't support the denial, so they didn't push it up. Now, usually they're not that creative in what they send to the Office of Hearing Operations, but you got to watch it. And they may not send this stuff from your own treating doctor, so you got to watch it. You may have to re-request stuff. It does happen.
I mean, this is a lot for somebody that's already sick and disabled to monitor.
I don't disagree. Keep in mind that the reason that non-attorneys are allowed to do this is supposedly this is a informal proceedings, the whole thing. So until you get to the Fed court levels of appeal, in theory, an ordinary citizen should be able to hack it.
In theory.
In theory.
I mean, I consider, I don't know, like, I mean, Liam, I would think like both of us would consider ourselves, to be fairly confident, people to a certain degree, but just like listening to you and all the steps and processes that these things go through is kind of, frightfully dizzying and labyrinthian.
Yep.
I
totally
recommend
agree.
a lot of my colleagues read their process, also translated in English as The Trial, but that's a bit of a mistranslation because continental Europe don't have trials. That's not a thing for them. Written by Kafka.
Yeah.
Particularly the sections regarding Block? The attorney talking to Joseph K. and the other client he has, who's like peeling his carpet at different points in the narrative.
I was just trying to think of like the ways that you can energize yourself to get through this process. Because
we
I
haven't
can
even
imagine
gotten through the whole process.
No, exactly. I know we only sort of touched the surface or skimmed the surface.
We've just gone through we haven't even gotten to the hearing stage. Like at the once you request a hearing, there's like a period of waiting before you get before the administrative law judge. That's when you actually have an in-person hearing. Although if you're doing a continuing disability review, they can do a hearing at the state agency at reconsideration, and that does happen.
Like if you think about an app on the phone, particularly like a banking one or one where you could buy shares or anything like that, they'll have several teams of people making sure that the user experience is as seamless and frictionless as possible, right? So that you can use their product and do what you need to do as quickly as possible. And it sounds like you said, maybe we're like 5% through the journey or something right now in your description. But
we're about half.
Right. Well, even if we're 50% of the way through, then it is not designed at all to be
user-friendly.
Yeah, user-friendly. It's designed, I assume it is designed. It's not just a consequence of a bunch of things that don't connect. I assume that there's an element of sort of bureaucracy built into it because it's not a priority for the state.
No, I don't think that's it at all. The only thing that is built that way is reconsideration stage. That is because they were thinking about taking it out to make it more user friendly.
Right.
And then they doubled down on going the other way because there are elements that are like that. One of those that's actually there's a bipartisan effort. Believe me, this is as surprising to me as it will be to you. There's so Title II has a quirky provision where they don't pay you for the first 5 months, kind of. Whether it applies or not can be a little tricky. But at any rate, there's a 5-month waiting period where the first 5 months that you're eligible for benefits, these are whole calendar months. So if your disability starts in the middle of the month, the waiting period doesn't start until the beginning of the next month. So a lot of people think will think of it in their experience as being closer to 6 months, because it can be. Because if your disability starts on the 2nd and you're waiting for the waiting period to start for the 1st of the next month, well, that's pretty close to 6 months right there that you're waiting. It's 1 day shy, literally. But that's designed in as a on the books appearing cost saving measure. It doesn't actually save a whole lot of money, but it looks like it does when Congress looks at the books, and that's why it's there. And there is a bill in Congress right now. It's called Stop the Wait Act because the thing's called a waiting period.
Right.
That's in Congress right now to get rid of that. So anyone who's on disability and wants to help make the program better, go talk to your congressman and senator today. Like literally, this is before the Congress right now, and it's bipartisan. If you're shocked, believe me, I'm shocked too. But it's a thing. I can give you the exact bill number. Give me just a second. I can pull that up because I have been campaigning to since I found out about this, because this has been in front of Congress for a few years now. And it's just kind of like sitting in various stages. HR 4386. Stop the Wait Act.
Stop the Wait Act. Finally, a bill.
It is a bill in the 116th Congress.
And that would reduce the time from 6 months to
0.
Right, great.
It gets rid of the whole thing. It also gets rid of the 24-month waiting period that's tacked on top of that.
Wait, what?
For Medicare eligibility.
So you have 2 years before you're eligible for quote unquote health insurance?
Yes, as a disabled person. Now, here's the funny thing. Here's the funny thing. Most people who get disability benefits, unless they amend their onset date at the hearing, don't actually experience it if they win at the hearing level. Because until COVID hit, COVID changed everything in a good way, mostly, in a bad way in other ways. But that's a whole conversation in and of itself, how COVID messed with things. Because Social Security actually got, in many of their departments, hyper efficient from working at home.
Huh. Wow.
And the unions for Social Security had been campaigning for this for years, especially the judges union. And yes, the administrative law judges at the hearing level are unionized, except I believe the ones at the National Hearing Center. For some weird reason, they're not allowed to be. I don't know how that works. That's what I've been told, and that makes no sense to me at all. And I haven't been able to verify it in like regulations or other law and policy materials. So I'm going to plead some ignorance on that. But it apparently there are some administrative law judges who are not allowed to be unionized, but the rest are, and they have a union. So this is one of the ways you know they're not real judges. Real judges don't have unions because they're bosses. Bosses don't get unions.
Right.
They get professional societies like the AMA or the National Bar Association.
Right.
That's the professional union equivalent. And even judges, real judges, don't even have that. I mean, I think they have like in California, there's a judicial conference, which kind of sort of functions similarly, but it's an organ of government. So the government can kind of put the thumb down on that too, to make it, bring it in line with policy. Because again, they're bosses. They're not workers.
Right.
But administrative law judges didn't originally have that title. They were called something like hearing examiner. And they were civil servants up until very recently. The Supreme Court actually made them officers, lesser officers, but officers under the Constitution. But in all other practical purposes, they're still employees. They have to be confirmed by the commissioner, not the president, and they do not have to be, appointed by the commissioner, and they do not have to be confirmed by the Senate because they're lesser officers, not like a department head in the executive branch. But up until the Lucia decision, it was not a Social Security decision, even though Social Security has most of the administrative law judges in the federal government. But it was a Securities and Exchange Commission Supreme Court decision, of all things. And that upended everything for Social Security because all of a sudden, none of the hearing decisions were valid. And so you had all these wonky appeals going to the appeals council and to the federal court going, my judge wasn't constitutionally appointed, so the decision is crap. Send it back.
Wow. Man, what a maze.
There were like thousands of those for years, for a couple of years there.
So we were, like you said, about 50% of the way through.
So, okay. We're at the hearing stage. They grant about, now, if you look at it nationwide, if you average it out over the nationwide, hearing stage grants about 50%, give or take. Sometimes it's as high as 60, sometimes it's as low as 40, but it hovers around 50% of the claims that remain from the third that were granted from initial application and the 10% granted at recon. So of the remaining, they grant about 50% year in, year out. Again, these numbers go up and down from year to year. The hearing office tends to be a little more swingy than the other numbers. And that's because the judges tend to be more swingy. Like in Phoenix, where I've done a lot of hearings. Phoenix and Phoenix North has a lot of judges that grant around 20 to 30% of all the cases that come in front of them, with one judge in particular who grants in like 75 to 80% in those two offices. And that's up until these few years.
It's like crazy to me that like these are decisions made by judges that aren't necessarily medical professionals.
Yeah, they're not. And here's the funny thing. They grant more cases than the medical professionals do, and they're way better decisions than the medical professionals. The doctors are horrible.
Why is that? Why do you think that is?
Well, the doctors don't, and the bureaucrat don't really understand the law. And it's not that the medicine is unimportant, but let's just say there's a shocking number of medical doctors who you can have a Google search and outshine their medical professional skill.
Right. Well, yeah.
And that's disturbing on all levels.
Wow.
I know this because I've done that in hearings.
Well, I mean, it's one of those things where, like, again, like, it's kind of, I mean, this is from like a listener and a non-legal professional. And
let me give you an example that happened early in my career. So there was a big fad for cases with back pain to do what were called Waddell signs to see if the person was malingering. And this was a big fad over all the different disability adjudication programs, not just Social Security. So we're talking VA, workers' comp. This thing got passed around. I think somebody did a seminar for one of the continuing education programs for these doctors, and that's how this came out. And so a lot of doctors were doing it, but none of the doctors had ever actually read the original research paper from Dr. Waddell and the people who worked with him. Well, by the time I was practicing in this line of work, it was available online for free. So I looked it up. This paper was written in 1980, the year I was born. Every physiatrist, neurologist, orthopedist that testified for the Social Security Administration as a medical expert had not read this. They were not up to date with the 80s. The 80s. Wow. And this was in the 2000s, the late 2000s, early 2010s.
Right. So how was the Waddell Act used in by medical professionals that didn't align with the research?
This is how they got it confused. Dr. Waddell indicated that there were certain tests that you could do that would show what he called non-organic back pain. And that wording was misleading to not very intelligent medical professionals with medical doctorates. And what it really was referring to was back pain that could be treated by back surgery, like a discectomy. And one of the things that it was actually objective evidence for was physical manifestations of things like depression. Now, you might not think of depression as having physical manifestations.
It absolutely
but it can. In fact, they treat depression, back pain, and seizures sometimes with the same medication. Usually they don't use seizure medications for depression, but they do use seizure medications for back pain. And they do use depression medications for back pain because all three of those are whole brain activities. And so medications that impact the whole brain impact all three or can potentially. And that's what Waddell was picking up on. Dr. Waddell got so ticked off at the misuse of his research by these charlatans that he wrote a follow-up paper saying, "What are you doing? Stop this. This is what I really meant. What are you doing? You're totally misusing my research." They still did it. This was all written before I started practicing. I kid you not.
Wow.
And that's a whole lot of orthopedists, physiatrists, physical medicine doctors, and neurologists who weren't caught up with the 80s, 1980s.
Yeah,
well,
it's disturbing.
Yeah, no.
And then you have, for medical consultants, one medical consultant always comes to mind, and this is not a joke. I did not make this up. I wish I did. There was a urologist who used to decide a bunch of cases for Phoenix by the name of Dr. Dick Stein.
Sorry.
I told you it's not a joke. But it's totally real. I must have objected to this guy's opinions more times than I can count. I never met him. I don't know him from Adam. If I were to see him on the street, I wouldn't be able to identify him. But we had disagreements that were fought in the hearing stage many, 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 many times because I objected to him and requested to cross-examine him over and over and over again. Never did get to cross him. But he would be ruling on back pain cases. And again, this is a urologist. What does he know about back pain? What does he know about rheumatological conditions like fibromyalgia or rheumatoid arthritis? What does he know about seizures? Again, urologist. He prescribes little blue pills, maybe.
Right. I mean, urologists do,
they do a lot of other things, but
yeah, they have a scope of practice, but back pain is definitely not
part of this.
Unless it's like a kidney related issue.
Right.
Because kidney issues can cause back pain, but outside of that very, narrow scope of, it's not the proper scope of practice to be ruling on.
Unless you have such a huge penis that it causes you back pain.
I've never seen that. I've not seen that yet. I've seen a lot of strange things. That ain't one of them.
There a lot of people do get breast reduction because of back pain, back shoulder, neck pain. Yeah, but
that's from deconditioning too. It's a combination of things because, and I wish they would teach this in schools for fitness. Your body is redundant. You have effectively two spines in your body. You have the spine that you know about, and then you have a spine that goes on your front. If you really think about it, the thing functions as a spine. You're starting with the sternum, and then once you get past the sternum, you have muscles that take the place of what the spine does for the back.
Right.
And this is why orthopedists and neurologists will prescribe core exercises for people with low back pain. That's where they're going with that. If you strengthen the core muscles, it will take a load off the lower back and the thorax.
It's like the brace for your spine. But yeah, moving on to the process end of things. So you're the hearing stage.
So after you do the hearing stage, it then moves to the appeals council. And the appeals council has a remand rate of about 20% these days. It's been slowly decreasing over time. The appeals council is actually where I think I've shined the most professionally. In 2013, I had a 75% remand rate with them, and in 2009, I had a 50% remand. And keep in mind, the remand rate in those years was something like 25 to 20% nationally. So those were freakishly high numbers. Then after the appeals council can act like the hearing level, or it can act like an appellate jurisdiction, because everything up until through the hearing level, they do de novo. All the appeals are de novo, which means that every time that you appeal it, they ask the question, are you disabled? From the appeals council level up, they start asking the question, did the administrative law judge make a mistake? And the appeals council is the last level where they ask the question, is the person disabled? But they very rarely ask that question functionally. But they do sometimes behave that way. You can have a hearing in Falls Church, Virginia. That's where the appeals council is, all of its branches, if they decide to resolve your appeal that way. But they only grant like 1% of cases outright. The 20% I mentioned were where they send it back to the administrative law judge with instructions on how not to make a mess of things again. If you want to think of it, it's like when you turn your an essay into high school teacher and the teacher comes back with bleeding red. The remand order is the appeals council effectively doing that to the judge's decision. Kind of. They just don't do it on the decision itself. They write a separate paper explaining what was wrong and how to fix it.
So what's the average timeline of like the process usually? Average.
Okay, so initial is about 6 months. Recon is about 6 months. This is all pre-COVID. Pre-COVID, the hearing would take about a year and a half to schedule a hearing, and then the hearing would have, depending on where you were, would determine how far out they had to schedule the hearing from that point. And then once you had a hearing, the judge would usually take about 1 to 4 months, and this is like 2018, 2019 numbers, that how long it took to get for the judge to get a decision out has varied wildly over the years since I've done this. And the federal court will not make them do with a writ of mandamus, will not make them issue a decision unless they have waited 3 years from the hearing date to get a decision out. And I've only seen that once since I've been doing this. And that was in 2006. So they've mostly cleaned up their act since then. That was under Commissioner Astrew. And he really did a lot to shorten the time frames to more reasonable amounts. Now, I have to put a caveat on how long it takes for a hearing decision to get out, because if you have Lauren Speck Havens out of Tucson, she can get it out in as little time as 1 business day prior to the COVID pandemic, and consistently got decisions out in less than a month. She's the exception to the rule.
Because, one of the stats that I was looking at was like, I think like on the app, this is kind of, the number isn't exact, but like around like 10,000 people that file for SSA disability die.
Oh, it's more than that.
10,000 people die before receiving a final decision on a year, every year.
Yeah, the field office gets about, if you limit it to a single significant figure, okay, because the number varies a little bit, about 2 million applications a year, and about it varies between 1 and 2 million of those go to the state agency for initial and reconsideration review.
So 50% kind of get like denied right off the bat.
Well, they're not eligible for technical reasons. They're not looking at it medically yet.
Right.
That the person isn't insured, the person isn't poor enough for Title 16, something like that. It's the state agency deals with the medical stuff. So that discrepancy is simply people who just don't qualify at all.
I'll have to look up the proper name or an acronym on Wikipedia, but there's what the system is, or what the system does is what it is, right? And if that many people were, because I was just trying to get my head around what the numbers must be in this process. Like, if 100 go in trying to claim a benefit and how many actually get it at the end, it sounds like it's a tiny number, but this whole process being so long, I kind of feel
it's
like
about 2/3 or close to 2/3.
Right. So two-thirds will get what they've asked for, or 2/3 won't.
Well, some amount of what they asked for. It's not always all of it, but yeah.
Okay. But with the time that it takes, there is maybe a cynical, or I don't know, realist perspective on all of this, which would say the system is this thing designed for people to die off in between time.
Well, most of the with the exception of like reconsideration and the waiting period that we talked about, most of this is it's designed to get rid of fraud.
Right.
That's the big concern, that people are faking it. Now, I don't buy this at all. And
the payout's too low.
Not just that. Actually, I have the perfect the perfect quote for this because, and it's from a surprising source. Of all strange things, a Reagan appointee. So what we haven't gotten to yet is above the appeals council, you have the federal courts. And you get the district court, court of appeals, and then the Supreme Court. And you can appeal all the way up to the Supreme Court. And people have appealed it to the Supreme Court. Rarely, very rarely. You don't see as many federal court cases as you do other up through the administrative levels, because at the federal court level, even at the district court, any case that you lose, you don't just lose it for the person who filed, you lose it for everyone who comes after, because it creates a precedent that will mess it up potentially for everybody else. So lawyers who do federal court work, they're very paranoid about doing one for someone who doesn't quite qualify.
Right.
This was written by Richard A. Posner, a Republican Reagan appointee. So this will be surprising in that context. Posner is a legend among disability practitioners as being like the best federal judge ever. And if that's surprising to you, I'm not surprised. But for disability law, he is a legend. And he writes in Sarchet versus Charter back in 1996, "It is fortunate rather than otherwise that not every person in the United States who might be eligible to feed at the public trough does so at the first opportunity. Many people are ignorant of the full range of available benefits or reluctant to undergo arduous administrative proceedings in which they are called liars until desperation resulting from personal crisis, or as here, the cutoff of other public funds drives them to seek additional information or to overcome their reluctance to run the bureaucratic gauntlet." Posner nailed it.
Yeah, that sounds just about exactly what, I mean, not to mention a lot of the social stigma that comes with.
Right. No, yes. Yeah. And Justice Douglas from the Supreme Court has a funny description of those medical consultants that I had been describing in the initial and reconsideration phase. This is how he describes them. "This case is minuscule in relation to the staggering problems of the nation, but when a grave injustice is wreaked on an individual by the presently powerful federal bureaucracy, it is a matter of concern to everyone. For these days, the average man can say, 'There but the grace of God go I.' The use of circuit-riding doctors who never see or examine claimants to defeat their claims should be beneath the dignity of a great nation. The problem of law is to let trial by ordeal of cross-examination distill the truth." This is from a very useful case for practitioners, Richardson versus Paralysis, which was made Social Security policy under SSR 71-53C. They just copied and pasted what the Supreme Court wrote, literally, with no interpretation. But so we went through the process way of going through. Now there's a different way of looking at this whole thing, and that is, what do you need to qualify to get this? And I said I'd put a pin on the grids and the medical listings. This is where I'm coming back to that. So there's 5 ways to get benefits. You can meet a listing. There is literally a list of medical conditions divided by body systems that lists out what medical criteria, what objective evidence you need to have in your medical records so that Social Security can look at that and say, hey, this person definitely can't work and definitely can't sustain work. Now, some of these things are set kind of weird. There's all kinds of debates that can be had about did they set it correctly? But those are built into the regulations to allow medical professionals to make decisions about these claims effectively. And that's why the initial phase, which uses doctors really tends to focus on the medical listings to grant cases. The next one are the grids. There are 3 tables in Appendix 2. So in 20 CFR Part 404 Subpart P, the 20 there is the Title 20 of the Code of Federal Regulations, Part 404 Subpart P, Appendix 1. Those are the listing of impairments. That's the medical listings I just talked about. Right next to it in Title 20 of the Code of Federal Regulations, Part 404, Subpart P, Appendix 2, is the medical vocational guidelines. And in there are 3 tables, which is where the term grids comes from. And this looks at your age, your, in a very, very broad sense, your past work history in terms of did you have a skilled, unskilled, or semi-skilled job? Your education, again, in broad strokes. Do you have a high school education or above? Do you have a limited education? Or do you have a marginal education? Or do you have difficulty reading and writing English? Which that last one got transformed under the Trump administration and no longer operates as it once did, because they were concerned that the Trump administration was concerned, and this will surprise no one, that illegal aliens were trying to get them benefits when that's impossible. It doesn't work like that. I know because I've helped immigrants get benefits, and you have to show Social Security as a color of law rule. You have to show that they're legally here or had a reason to believe, that's where the color of law comes in, a good reason to believe that they were here legally. They're not going to screw them up because the person made a mistake, in other words. But you have to show that if they are here illegally, it was an honest mistake, and they had every reason to believe they were here legally.
Right, they've been here since they were young children or whatever. Or
they thought they had a valid visa.
Right.
Usually it's not the children case.
Also, visas are also kind of labyrinthian in its process as well.
Right.
So.
Yeah, and that's usually where I've dealt with them is when it was something on that end where they had come in later. It's not that they had come in as a young child; it's that they had come in later and they thought their paperwork was in order and maybe it wasn't exactly. But at that point, Social Security stops caring as long as they were here under the color of law.
Right, but yeah, going back to the tables.
Yeah. So those tables allow people at age 50 I am overgeneralizing in the extreme, at 50 to kind of ignore sit-down work if they don't have any sit-down past work in their past that they can return to, and they don't have transferable skills to sit-down work, what they call sedentary work. And at 55, the grids allow people who are limited to light work to ignore light work. So if you're limited to light and you don't have any light or sedentary past work that you can return to despite your conditions, and you don't have skills that transfer to light or sedentary work, you can be found disabled despite being found capable of light or sedentary work at 55. And under very strict conditions at 60 and at 55, these are for very restricted education levels, you can be found disabled despite being found capable of medium work. And medium work is defined as lifting and carrying 50 pounds for a third of the day, 25 pounds for 2/3 of the day, being on your feet up at least 6 out of 8 hours, either standing or walking, and sitting for at least 6 out of 8 hours, generally. There can be some exceptions on the sitting part because generally medium work does not involve any sitting or very little sitting. After that, so that's 2, you have things that look like grid rules in that they take into account the age, education, and past work experience of the person, but are not found in Appendix 2. And these are found in the two of them are found in the regulations. All three are found in what are called the POMS, Program Operation Manual System. This is the policy book that is given to the field office and the state agency folks to make it easier for them to understand regulations, other policy statements like the Social Security rulings, court decisions that apply, that Social Security wants Social Security employees to apply, and other things. There are a couple of these manuals, but the POMS is the most regularly used. But there's a different version of this for like the telecenter. When you like call up their 1-800 number, they have a separate version of this that's solely for them. And so the three rules are the worn out worker rule, the house spouse rule, and the lifetime commitment rule. Worn out worker is 20 CFR for sections 404, 1562A. These are all worn out worker and house spouse are both at 20 CFR 404, 1562 and 416, 962. The difference is in the subsection. So worn out worker rules in subsection A, house spouse is in section B. House spouse was designed for originally around the idea of a housewife, but it applies gender neutrally. Basically, the idea is you're so old and you have no past work experience, so they're not really looking. They don't really require a whole lot for you to be considered disabled. And the house spouse rule only really kicks in for auxiliary benefit programs like widows and SSI. I mean, if you don't have work experience, you won't have, in the last 15 years, you won't have enough credits to get Social Security disability insurance in your own work credits. So it doesn't apply there. And the lifetime commitment rule is for very, very old people.
And ultimately, like, what is the payout and what are the restrictions to these payouts?
This all gets the same place. These are 5 branches to one tree. And so the payout is the same regardless of how you qualify. So if you qualify for Title 16, you get a Title 16 payout. If you qualify for Title 2, you get a Title 2 payout. This is just how you get there. The second to last one is what's often called by practitioners as less than sedentary, which is kind of a misnomer. But basically, this is where there is no work found that the person can perform. So the others were like cheats to get there. And the last one I'm going to talk about is a cheat to get there. But this is literally a vocational rehabilitation counselor in response to a hypothetical question saying there's no jobs performable. And by hypotheticals are things that are asked at the hearing level to vocational rehabilitation counselors in the capacity as vocational witnesses or experts, that where they look at particular limitations, because vocational rehabilitation counselors are not allowed to look at the medical evidence and not allowed to make medical determinations about a claimant. They just respond to specific limitations that are given to them by the judge or the advocate in that hearing and say whether or not in response to those set of limitations, can a person with those limitations work? And if the answer is no, this second to last way to win is the way that they win. Now, there are some sort of ways of getting there without the vocational witness, such as under 96.9p Social Security ruling, if you're limited to sit-down work and you cannot bend at the waist, that's considered disabling.
Oh, obviously.
It's not obvious. And I've had to fight with vocational witnesses on that one. But that's a thing. Another one is if you are unable to use both your hands and you're limited to sit-down work. under 96 Social Security ruling 96.9p, you can just win on that. But again, that's not obvious.
Well, I mean, if you can't bend at the waist, you know, you may not be like able to work I mean, that's like an essential movement, you know, just getting in and out of your chair.
You'd think so, but even the ruling says if it's less than complete preclusion, they might still be able to work.
It really reminds me of there was a Noam Chomsky talk or video where he was talking about the history of wage labor and how even at its inception it was considered a form of slavery, and that there's this all these details are like almost getting a permission slip from school that you don't have to do PE, you know, or you don't have to attend XYZ class, or just it's time off. Okay, you're allowed. You know, we see the circumstances, and you no longer have to be someone at work. I don't know. It's really distressing in some ways, but I guess, you know, this is Europe and America. I mean, not so different, and they are very different.
America is way more restrictive than Europe is.
Yeah.
By
it's that
leaps
market,
and bounds.
It's the market logic that sort of has permeated everything, right? That everything is justified on sort of economic means, rationality, and that is considered rational, is to make decisions based on market thinking. And it's, you know, it's corrupting, because from a moral standpoint, it's fairly obvious that you should be caring for people, looking after them. If they need help, if they say they need help, you give them help, you know, opposed to can you run through this gauntlet to get to the thing that you say that you need. It's you know, we did this episode a couple of weeks ago with a couple of guys who'd been to prison and the transition from prison back into regular society. And, you know, that's difficult enough, but actual prison is just raw punishment. There's no element of understanding or rehabilitation. It's cold, you know, and this sounds incredibly cold.
Cold.
Well, and a lot of people who are in prison are people who probably should have been on one of these two programs to begin with. I'm saying this as someone who's represented people who've been in prison
right.
for precisely that reason. I mean, I can't tell you how many times I've had a claimant who their limitation was because of their mental condition, they will randomly punch people in the face.
Wow.
You ask a vocational witness, can a person who randomly punches people in the face work? They're going to tell you no. I wonder why.
Right.
That's,
yeah, well, in that example, you can imagine
child molesters.
Whoa, okay, yeah, go for it.
And I happily represent child molesters. I have a big issue with them, but as the representative, I am happy to do it because I consider it a public service. You are helping them get the help they need, and you are taking them away from where they can do harm.
Right. I mean, that's
win.
Yeah.
Well, that's one of the difficult aspects of talking about a lot of policy, you know, because when it comes to disability, right, people kind of focus on the malingerers and fraud when that's like an extreme minority of the case. And, you know, again, when you're talking about, you know, a lot of sex crimes, right, you know, people don't understand oftentimes that, like, you know, having certain services actually is preventative and beneficial to society.
Oh, yeah. Well, part of the reason
Other than it's one of those things where it's crazy that if you are on whatever opinion about the sex offender registry is a very long conversation in itself.
Yes.
But if you are on the registry, it's kind of insane that you can't find housing and you become homeless. How is that going to you would think that would increase potentially the potential for reoffense rather than reduce, right?
Well, it's not even a question of whether it would. It does.
It does.
Because, I think it was right. Long Beach, in violation of California state law. I think it was the city of Long Beach. I might be wrong about this, and if I am, I apologize. But I think they housed a whole bunch of right. Specifically child molesters in a hotel because they had nowhere else to put them.
Right.
That would qualify with the law. So they're like, we're going to break the law anyways. So let's do it this way.
This is dark. It's very dark, but there was a episode of Arrested Development where they had a whole empty housing estate lot, and they realized that they could rent them all out to child molesters. And then one of the main characters goes for a cycle ride through the neighborhood. Yeah. And,
I remember that episode. Yeah.
And he's just really sort of enamored with all the attention he's getting. It's very dark.
They have to be separated by so many things, each one, which is part of what makes it so hard to figure out what to do with them. Well, but if they're on disability benefits for their medical condition, and in my experience, they're the easiest cases to win because the law actually makes it hard for them to find work. And what is Social Security asking about? What does your how does your medical condition restrict your ability to do stuff in the workforce? Well, society has said that it restricts you in XYZ ways.
Right.
That's a gimme. Right.
That's why I have no problem representing them, even though I have personal.
Right. Well, it's not about your personal opinion.
No, it isn't.
Of a crime, or that's not up.
Never comes into it.
Right. That's not up for debate. But
it's not something that needs to even be factored into this because. In helping them, and some of my colleagues disagree with me on this. I've gotten into some informal fights on this, but in helping them find housing and income, I am also helping there be less victims potentially.
Yes.
So
I agree.
This is harm reduction in the purest sense that I can contribute to that.
And it's because it's such a tricky area.
Well, they don't have to lie. The government doesn't have to lie to place them somewhere. They can go find a house out in the desert if they want to be away from everyone, if they want. And they can pay the rent, assuming it's not California. With the benefits, and if they're getting supplemental security income, they can qualify for Section 8 housing.
Well, and that comes down to one of the biggest, I think, case against, fraud and malingering is that you have to go through this entire process, and the payout is kind of extremely limited, especially in our current economy, isn't it?
Well, it depends. See, the Social Security insurance payouts are very different from the Title 16 payouts.
Right. So what are the various payouts?
So
the baseline.
So the Title II programs, whether you're talking about auxiliary or the worker getting it on their own earnings record, has a maximum and a minimum. I don't know exactly what the maximum and minimum are, but I can give you a ballpark. The minimum is somewhere around $400
a month.
Yes.
Mhm.
And the maximum is somewhere north of 3,000, I believe, because I've represented some people who made around 3,000 a month.
Right.
Now, 3,000 a month is exceptionally rare. That's for like people who do computer programming out in Silicon Valley, kind of thing.
Right. Those were people that were making like 6-figure incomes.
Or better than just over 6 figures. We're talking closer to 200,000 a year.
Right. So
not just, we're not talking like 100,000 a year and $1. No. We're talking much higher.
Right. You were talking like squarely in the 6-figure.
Yeah. Where the tax cap comes in. What people may not know is there's a maximum amount that they will tax people. When they talk about rich people are not paying as much into the system, that's true,
right?
Because they also don't get as much out. The benefit cap is tied to the tax cap. It's the same thing.
Right. Well, because the assumption is if you're making a shit ton of money, then like
you don't need it.
Yeah. You don't need your likelihood of needing these benefits is relatively smaller than somebody that doesn't make that kind of income.
Right. But they wanted the benefits available to everyone. And the reason for this was smart. They wanted everyone to have a stake in this so that it would never go away. This is also why they have the state agencies do the disability adjudication at the initial and reconsideration level. It's to stop congressmen from getting rid of the disability program because they would have to justify firing a bunch of state employees. Now, that might be easy for some Republicans to a point, but there's a lot of employees that would be getting the axe.
Do you think something like universal basic income, if it ever came to pass, would you still need like a separate income for disability related things that you need money for? Or do you think
yes and no?
Right.
Yes and no. And I think it could get rid of the SSI. I can see that because that's just giving you a floor.
Mm-hmm.
Right.
And UBI could be that floor. But the disability insurance really has a different function because the whole Social Security Act program, the whole Title II program has a function of getting people out of the workforce who society benefits from not having them in there. And when it comes to disability, this sounds really bad, but it's not. And with the retirees, it makes a lot more sense. You don't want people working into extreme old age because they'll be taking all the highest paying jobs in any given field. You want to open those up to people who are going to have families that they can use that money to help pay for their growing family.
Right. I mean, you would think that that's the original intent, right? That's
part of the original intent. Part of it was to help grandma not eat cat food.
Right. But right, that too. But so you're talking like $203,000 caps for this specific one. What are the other payouts?
Well, for SSI, it depends on the state because what happened is SSI was originally state programs.
Right.
That the federal government in the 70s, I believe it was part of the Johnson's Great Society. He took all of the SSI programs, Congress did technically, but put them together into a single framework that Social Security administered in those days under the Department of Health and Human Services. Social Security has since given the Department of Health and Human Services the boot and is an independent agency. But you have a payout of, I believe, let me give you an exact number. For 2023, it's $914 for an eligible individual And here's the real kicker. So there's a myth that, well, it's not a complete myth, but this needs explanation, that people on SSI can't marry. Technically not true, but also kind of true.
Right. You lose a lot of your benefits.
Not necessarily, but if you marry someone else on SSI, you have a maximum benefit of $1,371 for the two of you.
Ah, got it.
Instead of 914 times 2, it's 1,371 for the two.
So you lose out on $600 a month.
Yes.
Right?
Yes.
Which is a chilling. Well, I mean, it
is chilling.
It is,
but it's not. It's not like what happened to the homosexual SSI recipients when gay marriage was finally legalized federally. That was horrific, and that's a strange, untold story. If you have time, I'm happy to tell it.
Sure.
There was the Defense of Marriage Act that was on the books, and as homosexual marriage was being passed by Massachusetts, Hawaii, and so forth, the federal government said, we're going to legislate a exception to the full faith and credit clause of the Constitution. Now, how Congress can do this without a constitutional amendment is something of a mystery to me personally, but they nevertheless did that with the Defense of Marriage Act. Well, this allowed, in states that didn't recognize homosexual marriage, to get SSI if they were legally married to their partner.
Oh.
Think about this for a second. The federal government is saying homosexual marriage doesn't exist. We're going to clap our hands to our ears and sing la 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 to homosexual marriage. So for Social Security, this meant, well, the assets and income provisions that we would ordinarily deem from a spouse to a beneficiary of SSI, we don't have to do that because they're not married to us. Then the Supreme Court overturned that. And Social Security, you can go back and look at this. There were emergency messages that are available online. You can look at. They were going crazy like, oh my, there's going to be a floodgate. I remember because I was sending emails to all my fellow practitioners like, there's a whole bunch of people we represented who are suddenly going to be without benefits and without health care.
Right. But that did get overturned.
It did get overturned. Well, yeah, and they lost their health care because in a lot of the situations that I had personally seen, you had a disabled person married to someone with like a 6-figure income. And now the disabled person is going to be without health care unless their 6-figure income person extends their health care, which is wow. I mean, you might not be sorry for the people who have 6 figures, but they didn't all. And that probably broke up a lot of marriages because the marriage became unaffordable. And this doesn't get talked about because it kind of goes against the narrative that this was a universally good thing. I mean, it was a good thing. It was equal rights, but there were consequences. This was the consequence.
Right. Well,
and this is also the cost of bigotry. Republicans cost the federal government a lot of money to be bigots.
Yeah.
It's a story not often told. There was a fifth way that I did cover.
I've heard a little bit about it because I know, gay marriage has been contested by a certain aspect of especially the disabled LGBT community were somewhat vocal in their in the call for gay marriage because they were afraid of losing. They were afraid of exactly what you talked about.
Well, it depends. It depends on which program. For SSI, yes. For veterans, that's how it got overturned in the first place, was the veteran side of the coin, because veterans were being denied benefits, and people who weren't vets, they were the ones who were losing out on this. And so it was vets versus non-vets in the disabled community, which is kind of weird, but that's what happened.
But I mean, all these, it's just, I don't know, it just seems like, I mean, the more I listen to you, the more my stomach sinks and the more labyrinthian this whole process is. And it's not for a whole lot of money.
No.
And if you were a 6-figure earner, right, like a very high 6-figure earner, $3,000 a month is kind of a pittance, comparatively speaking.
Oh, yeah. Oh,
right.
Yeah.
But that's $3,000 for somebody that was earning a lot of money, like for other people. I mean, like, it seems like so you get like anywhere from $200 to $3,000 with this one program, and then Social Security disability insurance is $914. And I don't know,
depending on what state you're in, because it actually gets higher.
Right. Well, but but by higher, it's not like it's triple or double.
No, no. California pays the most, and they're weirdest. California is the only state where SSI does not play nice with food stamps. It's the only state. Every other state is fine with food stamps, but that's because the additional benefit, part of the additional benefit that California pays is in lieu of food stamps.
Right. How much does California get for?
Let me look that up.
Because I know like the maximum food stamp allowance for one person is like roughly like $280 or something to that effect.
Well, that's misleading. The Supplemental Security Income Guide for California says you may apply for CalFresh. No, you can't. It doesn't play nice with this, or unless they changed the rules. I don't think they did.
But the what's the payout amount?
$1,133.73. Unless you're blind, then you get more money.
Right. I mean, all these, like, it's if you're in an expensive city, like the totality of what you would get in disability still. I mean, because, you technically get Section 8 in a lot of cases, but there is a huge waiting list for Section 8.
Especially in California. I mean, you know this, but I was a former Californian. So, and I know people who are on Section 8.
Right. I mean, so it's one of those things where, like, all this labyrinthian effort and you can't even really pay rent. I mean, how is this an environment for malingering is something that I don't understand why that, Well,
that's why I read you the Posner quote. Right. Posner's the other side of this.
Right.
And I realize that's a weird person to be the symbol of the other side, but you got to read his decisions. There's a reason he's a legend.
I mean, and it's one of those things for broken clock, right? Conservatives aren't always wrong. They can sometimes. You're right.
He has a personal crusade for the for people who are not represented by counsel.
Right.
And Social Security is sort of his other crusade.
Right. Like I said, conservatives aren't always wrong, right? They can be right.
Well, in this particular case, he's not even conservative.
Right. I mean, yeah. I mean, just because you're a Reagan appointee doesn't necessarily automatically, especially for judges, because judge appointees and politicians are kind of a weird thing. But yeah, it's just, no, I mean, it's like all this bureaucracy for such little payout that's so punitive, because, one of the issues that I constantly heard from a lot of people that are, in this system is like, it's enforced poverty. They can't, the ones that like, because the policy doesn't really provide money for people who can't necessarily work full time, but would like to work.
Yeah, well, the work rules are labyrinthian. What I've just explained is paint by numbers. And paint by numbers law. And a lot of conservatives complain about California. There's so many regulations. Well, that's because California is a paint by numbers law state. Anyone can walk into a law library and figure out what they need to do. Now, you're going to spend the better part of an afternoon, maybe 2 or 3 afternoons, to figure out what you want to do. But you can do it. You don't need a lawyer, technically. Now, you may want to still consult one. I'm not saying that. But if you're going to have a paint by number law system, it's going to be very detailed so that even lay people can get it. You don't need to have a specialized education to do it. But that also means there's a lot of laws. And that's why, like, for Social Security, the POMs exist. A lot of people who do what I do like to consult the POMs, not because that's the best authority. It isn't. But it explains everything in plain English because it's written for social workers, not lawyers.
Right. But I mean,
and it even
still,
explains the medical stuff.
Right.
Because again, social workers, not doctors.
Right. But it's still like ultimately enforced poverty.
SSI kind of is. I can see someone saying that about SSI because of the different caps and stuff. And there's been a big push to adjust those caps. And that hasn't happened yet.
Do you see that happening in the near future? Or, I mean, because it's also one of those things where, like, would the adjustment actually address it to the issue that is necessary? That's where I'm really pessimistic.
It depends if it keeps adjusting. Like, some of these things had set in place a particular, like, dollar amount or other number. And then they put into the law an automatic adjustment. So you hear the substantial gainful activity amount goes up every year, and the amount that SSI get that they pay out for SSI goes up every year, and the amount that Social Security Title II claimant beneficiaries get goes up every year. Those are all tied to the consumer price index. And that was done so that they didn't lag behind too much. Now, the problem with SSI is the relationship between the consumer price index and those SSI numbers are ludicrous. And the fact that the amount that you can put in the bank has not been adjusted since the 70s, if memory serves me correctly, is even more ludicrous because inflation has, devalued that to the point of absurdity. You can't even repair, you're allowed to keep a car, but you can't keep enough money to repair it without someone else coming in and paying on your behalf. That's absurd.
Right. I mean, those are all kinds of, I know that, I know a couple of people that were talking on social media about the cost of the adjustment increase in their Social Security disability payments, kicking them, or various benefits, kicking them off of like Medicaid and food stamps at the state level.
Yeah. Well, yeah.
Things like that. It's just, it's one of those things where ultimately it just feels like, I mean, I really, really feel for, because, I'm part of a autoimmune support group. And I hear people constantly talk about applying for disability or, getting disability and not being able to make ends meet. And, and it's just, and also like all this, I mean, I understand that, you are the California, for example, is a paint by numbers law that doesn't necessarily require lawyers, but, it's also, it is impossible to navigate these fields when you're already sick.
Well, even if you're not sick, most people, there's a reason the Republicans whine loudly about California. Because if you make it a paint by number state, it's going to be labyrinthian. That's the cost of having it be paint by numbers. You can't have it any other way. The opposite of that is to have a bona fide legal priesthood who functions as a barrier between the citizen and justice, however you want to define that, or dispute resolution. And that has problems too.
Right. I mean, it just seems like the entire system is kind of stacked up against the poor.
Well, if you have a system that absolutely requires lawyers, yeah, that will be.
Right. I mean, like it's one of those things where, like, either way, small or big, what we currently have.
Yeah.
Yeah. And it's really, I don't know. We're almost coming up on 2 hours, so I guess we'll have to close out the episode soon. But and I really appreciate you kind of coming in and taking the time to kind of elaborate the system for people, because it's not something that people really understand unless they have to go through it. And even people that go through it are like, I have no idea what I just went through. I just know that I'm traumatized, right?
Right. No, I have those conversations all the time. I volunteer at a local psychiatric clinic explaining what Social Security is like to people as a volunteer thing.
Right. And, and it's just, it's one of those things where ultimately it's, listening to you, like, I'm actually like more depressed about the process of disability than I was before.
Well, like that enforced poverty you were talking about. One of the ways to not get caught in that, and not everyone's going to be eligible for this, but one of the reasons to fight for Title II benefits when that's on the table is to not be in that situation. That's the value of Title II, because Title II doesn't care if you get help from other places. You can sock money away. They don't care. So if Title II is on the table, that's the value of fighting for it. That's what that's worth. You get out of the programs that make it feel like it's enforced poverty. I mean, that's not the purpose, but it is where things fall apart. They don't go the way the designers wanted, the public wants, nobody wants, really.
Right. But I mean a lot of people aren't, generally speaking, like the most vulnerable people usually aren't eligible for Title II.
Not true. Not true. A lot of people who are disabled from birth get shunted to SSI, and no attempt is made to plan for adult disability benefits. And that's a mistake, because a lot of those people had a parent who did work and would be eligible for adult disability benefits maybe a decade in the future.
Right. Well, I mean, a lot of the people that I'm talking to mostly are people that become disabled as adults, whether through work or accident or illness.
Yeah. And a lot of those, they end up on SSI because evidence didn't get collected correctly or some other silly thing. With planning, some of the people who get stuck on SSI can avoid that trap. And my message to people who are disabled is you want to push for the Title II. You want to do whatever it takes if you can. It's worth so much to do that, because the workarounds for SSI are, we haven't even gotten into the whole third party, first party trusts situation for SSI. Like that's a whole other barrel of monkeys. We ain't even talked about that. And that involves a whole other specialty. There's a whole special collection of books in your local, if you're a Californian, because apparently the other 49 states don't believe in law libraries or something. It's very strange. But if you're a Californian, you can get a practice guide for this in your local law library. Every county has one.
Yeah, actually, that is true. We do have one in every county.
Yes, and the lawyers pay for it.
Right.
They pay dues.
And again, like it just seems like all these programs are not, it is so difficult to navigate unless, and especially for sick people, or people that are not in the best of conditions, right? Without, advocates and lawyers and just, a whole lot of, I just know so many people that give up on this process and end up homeless.
And I've represented my fair share of people who were living under bridges. Because, homeless, you can define homeless a number of different ways. There's everything from couch surfing to living under a bridge. And I've represented a fair number who were living under bridges. It breaks my heart. I've represented a fair number of people who died. In fact, I have a few coming up in the next couple of months where the person didn't make it to their first hearing. It's not like we went around the merry-go-round between the appeals council and the hearing level a couple of times, because that happens. They didn't even make it to their first hearing. Right.
It's just, it just seems like, again, that this is, we are not a society that is, that.
Well, one idea that advocates have floated around for years is, what if, there is a thing on the books to give preliminary disability benefits, and if you're found not to qualify, you have to pay it back. This does happen, actually. People do get preliminary benefits. I've never seen this, but it does apparently happen.
It's also one of those things where, like, you have to pay it back. Clawback is kind of the chilling effect for a lot of people, right? Because I know lots of people who, medically should like the number of people that I know that, have to go through this process multiple rounds before they're approved.
Yeah, but you could change that rule. And this is the idea floated by a lot of advocates. Because what if we had a system where, you have long-term and short-term disability? What if you had a system where if someone had a significant enough condition, and this could be defined a number of different ways, but just work with me on this, you give them a certain amount of money and you give them health insurance right off the bat. You give them the Medicare, you give them the monthly allowance so that they can heal, and then they can return to work. Because a lot of people become permanently disabled waiting for all of these social programs for for people with work preclusive disabilities to get their act together. And it goes from something that can go away and they can return to the workforce to something that doesn't go away. And part of that is on like workers' comp and stuff, because workers' comp was originally created to limit liability for the employers, which is both good and bad. On one hand, you don't want your local ma and pa store to be totally wiped off the map for a freak accident. On the other hand, having some multinational corporation only have to pay a pittance for something they know is going to cause harm to their workers, and they ignored OSHA regulations and what have you. Right. That seems a little...
I don't think small businesses are often some of the worst working conditions, so I don't necessarily...
There's that aspect too.
Have much... businesses are businesses, and
yeah. But the ability to pay between the two is radically
absolutely
different.
is very different. Is very different. Yeah, absolutely. It's just it just seems ultimately, this issue is similar to like a lot of the social welfare system in that ultimately, it ends up with the people in need, being distrustful and even justifiably hateful of the government and bureaucracy.
you ought to hear. I mean, I can't obviously divulge, but you ought to hear the conversations I have with disabled people who are Republicans, dyed-in-the-wool conservative Republicans who are now like, where's my money? Because they pay, and this was the beauty of the insurance portion of Social Security. It tied everyone in. So the Republican, not the leadership, but the rank and file, they're invested in Social Security. Maybe not SSI, but in the insurance program. And they're invested in it doing well and it helping the right people. And what usually needs to be explained to them is when Congress talks about fraudsters, they're talking about anyone who didn't win at the initial application, because everyone in government is kind of operating under the myth that those determinations are like 90% accurate. And I'm not even joking. But like when they talk about fraud in Congress for disability, they're talking about the people who are appealing these decisions. And when you see the quality of work from the doctors that are hired to be medical consultants and consultative examiners, 90% seems inversely high. Seems like you need to flip that, or very close there too.
One of the things that has come up several times on the podcast is that there's obviously some alignment, I guess, between a positive version of what mental health or health in general looks like and empowerment. And it seems to me that the system, in the process of navigating it, probably is quite disempowering, and probably if you're already in a distressed state, then you're probably defeated before you've even begun. So I'm wondering, have you seen with clients and stuff, like the ones who get through it all, do they have something? Are they angry? Like, in the sense that they know what they are entitled to and they intend to get it. Has there ever been any sort of thematic thing you've seen with different people?
Anger, no, usually. I mean, there are some people who are angry, don't get me wrong. I mean, it's not like you never see it. It's more defeated and depressed. As I was saying earlier, waiting for the system to get its act in gear and whatnot causes people to reach a point where it becomes the cause of their illness itself, a separate cause from what originally caused it.
Yeah. And
sometimes judges try to separate that out because, like, if we got you a job, that would make it all better. You've kind of taken them to the point where that's not going to happen. And we need to account for that. I think. Yeah,
there's the concept, or I don't know if it's even a concept, it's just reality, right? It's that society, the way society is built or structured, is what is defining what is a disability and what isn't, in the sense that it's the failure of a society to accommodate difference in ability, right? And so, like, that is an example of the same thing.
Yes,
the same, if not worse, maybe.
But it's a little more complicated than that. You're right. You're absolutely correct. But there's another layer. One of the biggest enemies of the disability benefits program is actually another disability community. And this may sound weird, but there's two groups of disabled people, and there's very little overlap between.
Interesting.
You have the work preclusive disabled. Those are the people I serve. And they're not going back to work.
Right. People that can't work.
Right.
Right.
For at least a year. And many of them, they're gone for good. They've their condition has made them check out of the workforce forever, unfortunately. I do believe that an awful lot of them, if we intervene sooner with money, with cash, we could get them back to work. But I don't see that happening. I don't see the political will for that, sadly. I hope so. And believe me, that idea gets floated around by advocates all the time. But then you have the other population of disabled. For simplicity's sake, let's call them the handy-capable, because they're the ones who like to use that kind of euphemism for themselves anyways. These are people who can work despite medical and psychiatric conditions, usually physical, but some of them also have psychiatric conditions, and they can work. They know they can work. They want barriers to work removed, and they see Social Security and programs like it as barriers in the way of them working.
Right.
So these are people who are ADA disabled, but not Social Security disabled, if that makes sense.
It does, yeah, because it's something that they want to do, right? Opposed to, yeah.
Well, it just seems though that, like, you know, I mean, you kind of see that kind of divide in a lot of ways with these kinds of issues, and it's, you know, the big, I mean, I feel like, you know, these divides among these people are kind of ill focused. Yeah. Right. Like, you know, people getting accommodations at work, like, you know, as someone who has had, you know, health issues, for example, you know, the ability to work from home, if, you know, your job is able to work from home. You know, COVID changed that in a positive way for a lot of people, and also a negative way for a lot of people, in terms of being able to work at home. But like, those accommodations are separate from these payments, and I think people confuse those.
Well, yes, they do, and they view that a lot of the handy-capable advocates, for lack of a better term, they view people getting these benefits as disparaging and maligning the handy-capable folks. Right,
which is unfortunate, which is, I think, you know, kind of really an unfortunate, you know, issue you see in a lot of circles, right? Like, for example, you know, you see that with the, you know, recovery community in terms of substance use, where, you know, people that recovered or people that are abstinent, you know, find that, you know, people who are not, you know, necessarily abstinent, but, you know, stable or functioning and contributing to society is kind of like a denigration of their efforts of abstinence, right? When it's like, right, you know, so it's kind of like a similar kind of battle in the sense of just, you know, people kind of eating each other alive rather than trying to expand for their own circumstances.
We haven't even gotten to the intersection of those two things. That's a whole conversation in and of itself.
Right. But I mean, like, you know, I mean, this is the issue of, like, you know, disability and marginality and society is a conversation that you could, you know, probably have for every day for 8 hours and still have things to talk about when the month is over. Right.
Indeed. Indeed.
You know, so for, you know, the purpose of this podcast, you know, we do have to wrap things up. But do you have any kind of closing advice for, you know, because one of the big things that I'm seeing a lot on Twitter, you know, and because of COVID, is a lot of people, you know, having prolonged symptoms, and, you know, some of them being very disabled after COVID, and they are now in the position of seeking, you know, help with disability. What is your, you know, advice for people who are in this position, or people who have families in this position, of where to start, how to get help, and how to get the best representation?
Okay, the representation question, that's a whole podcast episode in and of itself. So I'm going to put a pin in that. Because there are a lot of different perspectives that I should go over with that. What I would say is, you need to be prepared to be out of work for and without income, most probably, unless you have a spouse that works or you can live with a family member on their couch or something like that. You need to be prepared to be without income for 3 years minimum. And so however you need to organize your affairs to make that work, that's what you need to be thinking about. The next thing you need to, because unless you're found to meet or equal a listing, you're probably going to be waiting for a hearing. And right now, while the hearing level is going at light speed, I mean, we can't even get enough hearings in front of judges to fill up the judges' calendars anymore. They're going at Gatling guns paces now. It's amazing. But reconsideration is building up this mass of cases at the reconsideration phase that there's going to be a flood. In fact, there's a program where they're trying to figure out if they can just grant some of these cases on the record without a hearing. Some of the ones that are just coming in from reconsideration because there's such a flood that's expected, and it's been expected for the last half year. It just hasn't, the dam hasn't burst yet. We're waiting for the dam to burst all over the United States, and it just hasn't happened yet. So you might be waiting longer than 3 years. 3 years is based on pre-COVID wait times. But you want to be prepared for 3 years without income. You want to get your medical records together. You want to make sure your doctor is on board, your treating doctor who's seen you the most or is the biggest specialist, to the most highly skilled specialist. So if you have a back condition, this would be a neurologist, an orthopedist, a physiatrist. If you have a rheumatological condition, this would be a rheumatologist, most probably. Although it may, in some cases, also include a autoimmune specialist or an allergenist, so on and so forth. You want to make sure that they're on board with you getting disability benefits. You want to have that conversation before you file. You want to get ideally, you want a letter from that doctor that outlines how your medical conditions lead to concrete limitations that interfere with your ability to work, like sitting, standing, lifting, carrying, pushing, pulling, crouching, crawling, paying attention for 2 hour long periods. What percentage of the day would you be expected to be off task and unable to focus? How many days per month would you be expected to miss because you're going to doctor's appointments, because you're going to have pain days where you're just flat on your back, sitting, laying down on your bed, not moving, and someone has to come feed you. Those kind of things. There's psychiatric limitations to account for as well, but you want to get that in writing from the doctor, ideally before you file, so that you can turn that in when you file. And you want to know who all has your medical records. You want to get that figured out, because when you file, you'll be asked that. So you want to have that ready to go, ready to rock and roll right when you file. And if you are prepared like this, you're really going to up your chances of winning. And this is assuming you're treating. A lot of people, when they're filing, they're just barely treating. You want to go for the gusto if you can, because it's all based on the medical records.
Yeah, I mean, just listening to that, I see like enormous barriers for a lot of people.
Yeah, no, there are. And part of my job over the years has been at different times to light a fire under people to overcome those barriers, because part of the barriers are mental. And I don't mean psychiatric as in like depression or something, but you see all this stuff you have to do, and a normal person without disabilities in some of those situations would just throw up their hands and go, why would I bother? And then the person has limitations on top of that.
Right. I mean, 3 years without income just as a starting point is kind of, an intense ask.
Yeah. Well, the thing is knowing that's going to be a thing, you're not going to save up for that. That's a pipe dream. No one's saving up for that. But you do need to make preparations because you're going to have to pay for things, for medical reports and stuff, potentially, unless you hire an advocate who pays that for you ahead of time. But not everyone's going to do that. And if you get a legal aid, they may not be able to afford to. They may have to ask the doctor to do it pro bono. And if your doctor don't do pro bono, well, that's something you have to account for.
Right. And especially in our private insurance system, that just seems like.
Yeah.
Yeah.
That's why you want to have those conversations ahead of time, because there are whole doctors who don't believe that anyone is too disabled to work because they don't understand what that means and how little it takes to make someone completely unable to work. They think it takes like a Herculean thing. You have to be strapped to a gurney. No. That's not how this works. It takes a whole lot less to eliminate a person from all work.
Right. Yeah, I am very well aware of that unfortunate reality.
But you want to have that conversation with the doctor before you file. You don't want to be 2 years in and you've been treating with this doctor the whole time and you're about to get your hearing and you go to the doctor. You're like, please fill out this 6-page checkbox form for me because my attorney said you needed to do this, or my representative said you needed to do this. And they get this and the doctor's like, I don't believe anyone's disabled. Go fly a kite.
Right. I mean, it's also
2 weeks before hearing is not when you want to hear that.
Right. I mean, the difficult part also is, if you have private insurance, you can't, I mean, you need a lot of out-of-pocket money if your GP. You may not find a GP or a doctor. It costs money if your initial main doctor, whoever is treating you for the condition is like, I don't believe in disability, then, you often have to pay out of pocket to go find somebody that is willing to.
Yeah. No, you're not wrong.
It's just, it's an enormous undertaking that we are asking out of extremely vulnerable people.
It may also influence what state you want to live in. Like, that may encourage people to leave California and move to Arizona. Sounds strange, but Arizona had the Obama Affordable Care Act Medicaid extension existing before Obama was a senator in the Senate. California didn't. California, at the same point in time, was telling people, you're poor, go visit urgent care or go visit your local emergency room, and they will treat you as, they will keep a file for you. I know this because during that period of time, when I was working in LA, one of the main hospitals in LA closed. I believe it was Martin Luther King, if memory serves. And the whole hospital was downgraded to an urgent care because it was killing too many people from incompetence. And that became a huge problem for people in my line of work because we now had one less place that we could send people to get treatment. Not that you really want to send them to that place, but, what can you do? What's available?
Yeah. I mean, yeah. Well, again, thank you so much for your time for almost 2.5 hours of, trying to walk lay people through this, immense and soul crushing system. I really appreciate your time. Thank you so much.
My pleasure.
Yeah. It sounds like you really know your stuff as well. So like, that's the good thing. Like, you know your way through the labyrinth, through the gauntlet.
Oh, no, I was just about to say, if you have any documents or websites or links that you want to send over for people, to help people for our, episode show notes, please do.
Sure. We'll have a conversation on, afterwards about what you think is appropriate, because I wrote a whole bunch of LinkedIn articles mainly for professionals to encourage them to do certain things that I think are important. But there's more conversations to be had, and I am happy to have them.
Massive thank you as always to our VIP patrons, Rebecca Johns, Bruce Rogers-Vaughan, Alexander Lashley, Sheena Belmas, Seamus O'Connell, Alex Placito, Alexandra McCormick, and Wig Shaker.
If you have enjoyed anything you've heard Harriet say in this program, you will definitely enjoy Capitalism Hits Home, which is a solo program that Harriet does through Democracy at Work, which is a worker-owned cooperative that produces other great programs such as Economic Update with Richard Wolff and the Anti-Capitalist Chronicles with David Harvey. I can't recommend enough that everyone also listen to Capitalism Hits Home if you enjoy It's Not Just in Your Head.
And if you want to hear even more from Harriet, check out her radio show, Interpersonal Update, on WBAI and in the WBAI archives.